That's very generous of you, Nick. But I am assuming a certain level of base knowledge. Odds are, if you're on this webinar, you may well have seen our previous webinar about licenses and tenancies and things like that. So a lot of these questions are about the Renters' Rights Act. We're not covering the basic stuff. We're kind of covering applied knowledge here. So let's see if I can move these slides forward. That might be the main. There we go. We've got it. Great. So all the points that you're going to see on the screen are questions that I've received before this webinar. I have sometimes amended them, and some questions which were very similar I have overlapped. So if you don't see the exact question you asked, but see something very similar, odds are I might just have tweaked it ever so slightly, if only to fit more questions on the page. Let's get started. If students have an existing AST agreement with a fixed end date of July, and the AST is converted to a periodic tenancy on the 1st of May, how do I give 4 months notice to leave? So this question, the fixed term date is irrelevant because it's after the 1st of May. So we can rule that out immediately. The fixed term date doesn't matter. How do I give 4 months notice to leave? Now, what you're probably talking about there is ground 4A, which is the student HMO ground for possession. We'll be touching a little bit on that and any other questions too. You need to give, in order, a pre-notice. So there is a pre-notice requirement for ground 4A, which is to say, telling the tenants that you are going to rely on ground 4A at some point. There is a 1 month window from the 1st of May to the end of May to serve that pre-notice. And then the day after, you can then serve ground 4A, which is your 4 month notice period. And that's the thing that can only expire between June and September. Now, looking at the calendar here, if we're saying 3rd of May might be the earliest point at which you can serve this notice, then 3rd of September is going to be the last date at which you can serve this, which the notice can expire. Sorry, that'll be the earliest date at which it can expire. Which is already really encroaching on the next academic year. So it's not ideal, but it is all you can do in the circumstances. And I would be encouraging all notice you can serve ground 4A to do so, because this transitional year is going to be the hardest part of all of this. From next year, that pre-notice requirement, you just do at the start of the tenancy, and then you give 4 months, at least 4 months notice at some point in the academic year. So we're not going to be as rushed as we are going to be on the first few days of May. That's how you do it, basically. I will also have a section about tenants notice, because tenants notices are also relevant here. It may well be once it goes periodic, tenant gives their own notice to leave, in which case you get the property back. Like I say, managing this transition is going to be the most crucial part of this. So if a tenant gives their notice, in a way, I'd be thanking your lucky stars that they've gone, and then you could kind of manage a more organised assured tenancy from the next academic year. If the tenant's notice is withdrawn and agreed to, will this create a renewal and a clock reset for the service of ground 1 and 1A? Now, this is quite an interesting question. I've put the words current tenancy in there, because the way in which this is worded in Renters' Rights Act is it says you can't serve, or rather, the ground 1 and 1A, those notices can't expire within 12 months of the current tenancy starting. So if you were to create a new tenancy, then that would reset the clock. But going back to the question here, a tenant giving notice, and the agreed to part here is the landlord, I guess, agreeing to it, but they actually kind of stay. In that circumstance, I wouldn't say that creates a new tenancy at all. It's just that the existing tenancy didn't end. So I don't think that creates a new tenancy, and therefore it doesn't reset the clock. Do Section 8 notices via ground 1 and 1A for need to expire at the end of a rental, at the end of a period of rent? No. Now, this question was quite detailed, and I enjoy these questions because it gives you something to really sink my teeth into. So, well done to this person. You've got yourself. You've got a slide all to yourself. This is about ground 4A, and one of the restrictions on ground 4A is that you can't serve it if a tenancy was entered into more than 6 months before the tenancy started. Now, this is one of those late additions to the Renters' Rights Act, and to be frank with you, I don't truly understand why they did it at all. The fact is, it's in there. If you enter into a tenancy more than 6 months before that tenancy starts, then you can't serve ground 4A. And just for clarity here, in this one transitional year, that doesn't apply at all. This would just be coming for future years. And the way around it, I suppose, would be to kind of hold fire. You can line up your tenancies, but you can't create the tenancy agreement unless you're within that 6 month period. Now, this person's basically saying, well, what if I just don't do that? What if I just create the tenancies when I create them? And then we're leading it, and then we're also segueing into a civil penalty. So there is a penalty if you serve notice and get possession on the ground which you're not entitled to rely upon. And here, the landlords would not be entitled to rely on ground 4A if they've created tenancies more than 6 months before the tenancy starts. So there's the real question here is about penalties related to Section 8 notices. They've asked, is it a sliding scale or would it just be a flat rate of £7,000 per offence? It's not a flat rate. It does scale. So 7 is for the first offence, and then it scales up to 40,000. Now, that's not to say you're going to get, it's not going to go 7 and the second penalty will be 40,000 necessarily. It's more just that that's the spectrum. But at a certain point, yeah, you probably would be pushing at 40,000 if you keep on breaking the law and keep on doing it. I mean, obviously, at a certain point, you're not making any money from this if you're practicing this way. But the flip side of this question is that the local authority has to find you and prosecute you. It's entirely possible that a lot of landlords will, just to use the expression, get away with it, serve notices that are not necessarily entitled to rely upon, and there is no consequence for that. I'm not encouraging that, but this question is really about risk management. These people are saying, if I break the law in this way, what's the consequence going to be? I hope I've given you your answer. This question here, it says they have to give 2 months notice and the landlord has to give 4 months notice. How can that be achieved? This person has misunderstood what the rules are. So both the tenant's notice, which is the 2 month notice period, and the landlord's notice, being the 4 month notice period, they are unilateral notices. That is to say that one party can do it. It doesn't require the other party to consent to it. So we don't need both parties to give notice. If both parties want to surrender a tenancy, that's totally legal still, that's fine. But both parties have to consent. When we talk about notices, we're talking about one party saying, I want this contract to end, and then there are minimum notice periods for each. So I included this one just to say, I think this person's probably misunderstood what the rules are about. Notice periods are about one party ending. The other party doesn't need to agree to that. Ground 4A requires pre-notification. Now, I did touch on this, but just in case you weren't listening or you came in slightly late, you have 1 month from the 1st of May to the end of May to give your tenants pre-notice that you are going to be using Ground 4A. I would be doing this as soon as possible. There's no reason to use the whole month. I think every landlord needs to be looking at these dates specifically. So 1st of May, law comes in. 2nd of May, serve the pre-notices. 3rd of May, serve Ground 4A. That will be the idea. But yeah, in theory, you do have slightly longer. I wouldn't be risking it. If there is a mixture of students, graduates, how do we get possession? Now, again, this relates to one of those preconditions of Ground 4A. Ground 4A says it only applies to student households. If you have a mixture, you simply can't use Ground 4A. That's the answer to this question, is you cannot mix it like that. If you have graduates, then you are creating an assured tenancy which can run unless one of the other possession grounds apply or unless those tenants give notice. Don't mix. Section 21 notices. I think there was only one question about this, but it's kind of the key question. Section 21 notices currently have a shelf life. Proceedings need to be issued within 6 months of you serving the notice, and that 6 months includes the 2 month notice period. So you kind of have this 6 months, 2 months as notice period, and then you have this window of time, which is less than 4 months to issue proceedings. That shelf life will continue to apply, except there will be another shelf life introduced by the Renters' Rights Act, which comes in on the 1st of May. And it basically says you have until the 31st of July to issue your proceedings. And whichever one of those two dates comes sooner, that's when the Section 20 notice expires. So as an example, it's the 15th of January today. We serve a notice today. We have until the 14th of July to issue proceedings on that notice. If it a month from now, the 15th of February, we have until the 31st of July to issue proceedings. And that's because 6 months from the 15th of February is the 14th of August. That is later than the cutoff date introduced by the Renters' Rights Act. So we will shortly be at the point where Section 21 notice periods, or rather the period in which you can issue proceedings on them, are going to get shorter and shorter and shorter and shorter. And again, just to be really clear here, the day before the legislation changes, so 30th of April, you could serve a notice, and but that would you'd have to issue proceedings on a notice before the 31st of July. So you're giving yourself a very short window, bearing in mind the 2-month minimum notice period. Again, if you're going to be doing these things, it's best to be organised. But I dare say there might be a small rush for the exit come July. I'm expecting a very busy end of April, because I think a lot of landlords will suddenly say, I need to do something now. But you don't need to necessarily wait that long. One caveat to all this, anticipating questions. If your fixed term expires after the 31st of July, there's no way you can serve a valid Section 21 notice, because your notice would either expire after the 31st of July, which is what this question touches on. In which case you can never issue proceedings on a notice, or it expires before the 31st of July to try and get in before this deadline cuts off. But that notice would also be invalid because it would expire before a fixed term. There is potentially some weirdness about what happens if a tenancy essentially the fixed terms come to an end on the 1st of May. I wouldn't want to be a test case for that. So I would just say, if you find yourself in a scenario where you're arguing that fixed terms come to an end, that there might be a way forward there, but very risky to do it. And as with a lot of people talking about Section 21 bans, there's usually a motivation behind getting possession of a Section 21 notice. So if you want to sell the property, move back into the property, there's antisocial behaviour, you don't need to risk serving a Section 21 notice on which there might be appeals, across appeals, and all kinds of issues raised. If you could just serve a Section 8 notice, most circumstances which landlords want to serve a Section 21 notice, you will be able to serve a Section 8 notice on those circumstances in the future too. So just something to bear in mind. Section 13 notices, so rent increases. Is there a limit the landlord can put the rent up each year? No. The increase has to be in line with market rate. The property tribunal have means of assessing what the market rate is, and then they can set a figure. But in principle, if the rent on your street has increased by 100%, then in theory that's the market rate. I'm not sure what circumstances would lead to that, but in principle there's no limit. Will we be able to serve the current Section 13 notice take effect after the 1st of May? Yes. If you are issuing a new tenancy agreement when you are doing a change of tenant, does the rent review move to 12 months from the new tenancy agreement, or is it on the anniversary of the original agreement? Now, there's something in this, and I think I have a future slide about issuing new tenancy agreements, because by all accounts, there isn't actually any need to issue any new agreements. Renewals will go the way of the dodo. The rent review doesn't necessarily conflict with that, though, if you were to do it. So imagine you're creating a new periodic contract after renters' rights comes in. The rent isn't changed as part of that. Then I don't see any reason why you couldn't do a Section 13 notice 12 months after the start of the original tenancy, whenever that happens to be. It's just, I think this is a bit of a false dichotomy, because you simply wouldn't give them a new agreement. General contract questions. What type of contract will now be used for student let? Now, the default position is it's going to be an assured tenancy, and then you have ground 4A to end that tenancy. The only other type of tenancy that might apply would be a non-housing act tenancy, which you can only use if your tenancy falls within an exception to the Housing Act. Purpose-built student accommodation providers are going to fall within that exemption because of the new exemption created, so they would be able to utilize that. But your average landlord, highly unlikely you're going to fall within one of those exemptions. The third category would be a license for the property, in which case you need to be, well, first of all, seeking legal advice on it, because licenses are tricky businesses. It's not at all clear whether or not you'll be able to kind of get away with it, and I would expect there to be a lot of case law in this area in the future, because a lot of landlords are going to be leaning into licenses as a means of trying to avoid the Renters' Rights Act, and so you can expect increased scrutiny from the local authority, who, let's not forget, have additional investigatory powers as part of renters' rights anyway. So you expect there's a potential for a lot of heat on you if you're handing out licenses as opposed to tenancies. But those are the three: assured tenancy, non-housing act tenancy if you fall with an exemption, licenses, but you need to be taking, I'd say, legal advice, and at the very minimum, you have to be providing a lot of services that would encroach on a tenant's right to exclusive possession of the property. Segueing into question 2, which is about PBSA. Are PBSA operating using fixed-term common law agreements? Yes, they are. And are they exempt from renters' rights bill? Yes. If so, is registration under the approved codes a prerequisite? So the way in which the PBSA exemption works, bearing in mind we don't actually have the full regulations on this yet, we just have the mechanics of how the regulations might apply. But the regulations will specify type of landlord, a type of building, and a type of code. And a person must be a member or employ a letting agent who is a member that fulfills all of these categories. So basically, you have to be a landlord of purpose-built student accommodation, and you or your agent have to be signed up to the ANUK/Unipol code. That's what the proposed regulations are going to look like. It's foreseeable in the future that you might get more codes created. So let's say, for example, we created the accommodation for students code, and that allowed student HMO providers to sign up. That's possible, but that isn't going to be the case day one. So for now, unless you are a PBSA provider, disregard all this talk about non-housing at tenancies because it simply isn't relevant to you. But keep your ear to the ground. Like I say, I reckon there could well be some development. NRLA code, there could well be some codes created precisely to facilitate smaller landlords rather than having kind of the big boys and girls of this sector kind of having their own rules. We find it hard renting our flats to anyone other than students. When this new bill comes in, can we carry on a yearly tenancy so we know where we are? No. The best you could possibly do would be to serve round 4A, and that way kind of artificially creating a fixed term by telling the tenants they have to leave by a certain point. I personally think it's far more likely that students, the problem for student lounges is going to be students giving notice before a fixed term would have ended. So, for example, May, most fixed terms don't expire in May. I think a lot of students are going to be giving notice early, rather than the problem being we can't get these students out of our house. So I think it's very good form to still be doing your ground 4A and making sure you're doing what you can to maximize the chances of getting possession back. But no, you can't create a fixed term. Do we have to issue new contracts on the 1st of May to existing tenants? No, you don't. There is going to be a document created. I don't think we've seen even a draft of it yet. But there's going to be something. It's going to look and feel a lot like the How to Rent guide. It's basically just going to be information to tenants and telling them what the law changes are about. You will need to provide that within a fixed period of time, but you don't have to create new contracts necessarily. Your old contracts, which are fixed terms, presumably would automatically convert to periodic contracts. So that's fine from a paperwork point of view. We should. I'm trying to remember what the ministry's guidance said about timings on this. I think they were going to make the document available a good month or so before 1st of May. So it shouldn't be hard to source this thing. You should be able to just download it from the government website, make sure it's given to all your tenants, and then you're good. If I use the license to occupy option, does this put me outside the cannot charge more than 1 month's rent rule? Would I be able to continue with my termly rent invoices? Yes. So the way in which the Renters' Rights Act and the Tenant Fees Act works with regards to advanced rent, and we'll be touching a bit on advanced rent later on specifically. They're all about assured tenancy. So basically, if you're creating assured tenancies, then certain rules apply. If you're creating licenses, then this is one of the advantages of creating a license, is that certain rules don't apply from you, and the rent advance is one of those rules. What legally binding contract can landlords use to ensure students will move out at the end of the academic year? I like this question, and I could have edited out the words legally binding, because the landlord asked this question because they want something that's robust. I'm afraid to say the thing doesn't exist. You can only issue, like I say, those 3 types of contract: assured tenancy, non-housing at tenancy if an exemption applies, licenses if you've taken proper legal advice and you are providing services. those are the three types of contract. There is no contract you can use, and I want to be clear. The same is true right now. If you're giving out assured short hold tenancies now, presumably that contract doesn't ensure that the students will move out. It just means that you have the option of serving Section 21 notices, but most students move out, so that hasn't ever really been a problem. I don't think any student lounge are all, as a matter of course, serving Section 21 notices because most students go, but you have the option available to you. The only difference is in the future, you won't have that option available to you. The only thing you can do is to, assuming you go with an assured tenancy, which is probably most people will do, assured tenancy, serve your ground 4A notice to expire in June to September, and then you're kind of just hoping the tenants leave. If they don't leave, just as now, you would have to evict them or just accept that they are moving into the next academic year and adapt to that. It's not a particularly desirable answer to your question, I'm sure, because I think what you were looking for was here's the magic wand to solve my problem. I'm afraid it simply doesn't exist. These are the rules. We are being constrained, and that means you can either try and find ways around it, leading into licenses. You could not comply, which, to be crystal clear, I am absolutely not encouraging you to do. You should be complying with the law, or you adapt and just move with it. And you actually perhaps find out that students leave when they want to leave. They don't want to be liable for rent them longer than they have to be. So it might all work out. That might not do much for your blood pressure right now. Would you suggest including a clause in the tenancy stating notice from one of joint tenants will be considered notice from all of them and so they all need to vacate? Now, the law in this area, student notices in particular, and I say there is a student notice section coming up. The law in this area is that one tenant can serve a notice to quit on behalf of all tenants, or rather, to put it another way, when a tenant gives a notice to quit, they are ending the entire tenancy, not just their part of it. So, in a sense, this clause is redundant because that's already what the law is. And the reason why I've left this question in is to explain that's what the law is. But yeah, in theory, if you were to put a clause in there to say that, that shouldn't be a problem on the basis that is what the law is. Now, the law may change, and you can probably expect some development in this area because the law for ending assured tenancies has really only progressed through local authorities because local authorities can't give out assured short hold tenancies. They've had to be giving out short tenancies, and so they've had to do certain things, like, for example, issue possession proceedings on a notice that a tenant has given, and then that expands the law. But if the entire PRS is now swapping over to assured tenancies, which I'm expecting they will be, rather than trying to avoid it entirely, most people will be going to assured tenancies, then we could probably expect the law to develop in this area. I mean, that said, it's been 10 years since the Section 21 rules were changed to link them to EPCs, gas safety, how to rent guides, and we're still getting developments in the law with regards to gas safety certificates 10 years on. So I'm not saying it'll be a quick change in the law. You're not going to get day one, the cases going straight to the Court of Appeal, but gradually the law will evolve, and so you need to make sure that if you do insert clauses like that, they are also moving with the law. Otherwise, you're going to have an unenforceable clause in the contract. Can I still advertise the properties more than 6 months in advance if I have written confirmation that the current students indicate they will move out by will move out by July? So I think this is linked to the exception of ground 4A, which is that the tenancy has to be entered into within 6 months of tenancy starting. But I'm really focusing on the keyword here, advertise. You can advertise that property whenever you like. The ground 4A restriction is about entering into a tenancy. And again, this is an area where I reckon there's probably going to be some developments in law. What does entering into mean? Well, I would say that's when the parties sign it and date it. You can definitely tee things up, and I really think this is okay. Is if you have your property listed on Rightmove or other portals are available. You get the tenant who's making the inquiry. You say, okay, as far as I'm concerned, we have a deal. However, I can't actually send you the contract yet. I'll have to wait until 6 months before it's due to start. It's a bit of a leap of faith for the prospective tenant, perhaps. Again, I don't think there's much you can really do about that. Otherwise, you're going to find that if you wait until that 6 month window starts, some other landlord has probably stolen your lunch already, because obviously this restriction only applies to landlords who want to use ground 4A. Do you know who don't need to use ground 4A? PBSA. The PBSA sector do not need to use ground floor A, so these are not restricted in this way. So the PBSA can fill up and create contracts more or earlier than the 6-month window starts. And so there simply may be a smaller field if you wait that long. So like I say, advertising early, teeing things up so that when you can give the tenants that contract and you enter into it at that point, then you'll be able to do ground floor A notice as well. Post 1st of May, would it be possible to do tenancy renewals and be increased rent via tenancy renewal? Now, whoever asked this question, massive gold star, because you have got yourself your very own slide, because this is quite technical and there is all of some speculation on my part. It's a tricky question to answer without a crystal ball. So the current rules, Section 13 of the Housing Act, that's where we get the Section 13 notice from, Section 13 of the Housing Act, currently says, amongst other things, that nothing in this section, to do with serving Section 13 notices, affects the right of the landlord and tenant to agree a different rent between themselves, right? That's currently the law. You don't have to increase the rent through a Section 13 notice. You can increase by agreement. However, renters' rights introduces two parts. The first part is a new Section 13 brackets 4A, which says that the only way you can increase the rent, I've paraphrased this because the wording is longer, but the only way you can increase the rent is by Section 13 notice, the tribunal assessing a Section 13 notice, or there is a way for the tribunal to assess rent at the start of a tenancy too, or an agreement between landlord and tenant following a tribunal assessment, and the rent has to be lower than what the tribunal set. So nowhere in there does it allow the landlord and tenant to agree the rent change. Also, Section 13 brackets 5, which is that top paragraph in italics, which is currently the law, that says you can agree it, that's being abolished. And what there is instead is a wording in Section 13 brackets 4B, which is very similarly worded, but not quite the same. It says, except as in Section 4A, so that's that list of 3 bullet points in the middle, except as in Section 4A, nothing in this section limits any right of the landlord and tenant to vary any term of tenancy by agreement. Now, that's very similar to what Section 13 brackets 5 says, except Section 13 brackets 5 says, in brackets, I'm using the word brackets a lot, says including a term related to rent. And the new one does not say that at all. That indicates to me Parliament's intention to not carry this over. They specifically abolished the old wording, and then they've introduced wording which is not the same as the old wording. That said, vary any term of a tenancy by agreement. If it didn't have those, if the original wording didn't have those brackets, I think that would still apply to rent increases, because any agreement or varying any term of the tenancy, paying rent is one of those terms. So I think what you could have, if you imagine a Venn diagram, all the terms of the agreement is one circle, and then within that is including terms related to rent. So if you have permission, which this new clause says you do, to vary all the terms by agreement, then you also have permission to vary the terms relating to rent. So by explaining this, I have introduced two completely conflicting arguments, and I simply have no idea which way it's going to go. This needs to be fleshed out. But I reckon that Parliament's intention here, by removing the original wording, why would they do that if not to create different wording? They could have left it as it is, but they specifically removed the part which said including the terms in relation to rent. So I think their intention there is that you can't do it by agreement. So going back to the original question then, will it be possible to do tenancy renewals? That's one question, and we've already touched on that. The answer is, I guess you could, but there probably wouldn't be any point, because what are you renewing? There's no need to create a renewal unless, question part B, you are trying to increase the rent. It's a tricky sort of thing to do. I think you probably could do that if you surrendered the tenancy and then created a new tenancy, because those are distinct things. But again, I reckon there's probably going to be some argument here that you're trying to get around these 3 bulletins in the middle, which is basically saying this is how the rents increase, and actually that surrender re-grant is a bit of a scam, or a sham, I should say, not scam, because you are trying to get around these provisions that stop rent increases. So yeah, very tricky answer there to a very tricky question. I think you're risking it if you're trying to do it that way. Tenants' notices. So what is the process if one tenant gives notice but the rest want to stay? Who fills the newly vacated room? Me, the landlord, or the remaining tenants? Um, so the law here is, as I said earlier, that one tenant's notice counts on behalf of all of them. It ends the entire tenancy. But if you have people who stay beyond the notice period, I think the parties are really just going to have to try and muddle through this as best they can. So if you have one person who leaves, three people stay, the landlord either has to try to evict those three people, or they just have to say, look, I just need to fill a room. So I'll search for a tenant. You maybe ask your friends. We'll see if we can cobble together some kind of new arrangement. I really think both landlord and tenant have an incentive here to try and make it work. If not all the tenants are going to leave. So I think this is really a case of being pragmatic rather than saying letter of the law. The letter of the law is that tenancy the entire tenancy legally comes to an end, and the landlord needs to try and evict them as trespassers. But if you're saying they're trespassers, you're also saying that they are not tenants, and therefore you shouldn't be taking rent from them. It might be easier just to try and say, okay, we'll just try and make this work as best we can. You can also create, I would say, you can create implied tenancies. So if everyone just behaves in the same way, the tenants stay where they are, they keep paying rent, landlord accepts the rent, everyone's happy, you might have an implied tenancy arising. I would say the courts have been slow to interpret implied tenancies. Tenancies have a lot of obligations on the part of the tenant. They also have a lot of obligations on the part of the landlord. The courts are slow to say that, oh, that's definitely an implied tenancy. There usually has to be quite a considerable period of time for that for you to be in the clear. This might be a scenario where you just create a new agreement. So with the three remaining tenants, just create a new agreement with them. And if everyone's happy, that can just exist as a new agreement. The clock would reset for the purposes of your ground one and ground 1A. And but also giving a written agreement that will also solve a problem, because one of the penalties you can get from local authority is not providing a written tenancy agreement. So if you have an implied tenancy with just these three people, that's not a written tenancy agreement. You can actually be penalised for that. So having it in writing, just kind of accepting that we are where we are. The three people are obliged to pay the rent. They seem happy with that. Just see if you can make it work. It's a tricky situation, this, because the law really doesn't cover this scenario particularly well. Is there a means to ensure that tenants stay until the end of the tenancy term, or would they be able to leave before the end of fixed term? No. It would presumably be better to start the contract in July in the previous year to ensure 12 months occupancy. I think what you might be talking about, I actually, to be honest, I'm not entirely sure what you're talking about, because the fixed term, the fixed term ceases to be relevant after the 1st of May. But I guess you're talking about after May, aren't you? So you're talking about it starts in July, in which case you have your new tenants pay rent for the property over summer, and then it goes around. And if obviously the new tenants can give notice, I think this question is accepting of the fact that these tenants give notice. But what this landlord is perhaps trying to do is to cover off kind of this summer void period by basically saying, okay, rather than it being kind of at the end of the contract, why don't we have it at the start of the contract? Now, there's no reason why you can't do that. That's perfectly okay. The question is, are you going to find students who want your property desperately enough to basically pay 2 months rent for a property that they might not even be living in? I don't think the market will be particularly happy with that. I think you'll simply find fewer students will want to let on that arrangement, when they could just say, why don't we just save ourselves 2 months rent and take a tenancy that's going to start in September when we're actually needing the property. Of course, some students want the property over summer. That's perfectly fine. Yeah, that can be okay. Just see how far it gets you. How are we doing for time? We're doing okay for time. Good. Tenants notice part two. I think you're asking the current students to formally give performance notice, but can they do this in March prior to that? So I think this person is just a little bit confused. So students don't have to give 4 months notice. Under the rules, they need to give 2 months notice, or less than 2 months notice if it's been agreed. But let's just say 2 months notice, just to save me saying lots of unnecessary words. So the notice period would be 2 months. You could ask the tenants to give you 2 months notice. That would be perfectly fine. Obviously, the tenants don't have to give you 2 months notice. If they don't want to leave the property, if they want to leave the property, they have to give you 2 months notice. Can they do this in March prior to act implementation? Yeah, yes, I think they could do that. on the basis that right now they have a fixed term which will expire at a certain point. So they are contractually bound to the fixed term currently. Let's just say it's in July. If they give a notice now and say we want to leave the property in July, that's valid notice. That's fine. When we talk about notice periods, we only ever really talk about minimum notice periods. So here, the tenant is basically given 7 months notice or 6 months notice. That's fine. They're allowed to do that, but they can't unilaterally end their contract earlier than that. However, come 1st of May, they could give that notice. And I wonder, I might be reading too much into this question, but is this person asking, can the students give notice now to expire on the 1st of May? I don't think they can do that because the law doesn't currently allow that to happen. I think it has to be after the 1st of May. Second question. So in a student HMO with an existing AST ending in July, again, fixed terms are relevant here, so disregard that bit where it ends in July. 2 students want to stay, 2 students want to leave. Should I give them all letters to quit and when, or leave 2 under the period of contract? I think this dovetails quite nicely with what I was saying before, which is just you need to find a way to make it work. Either those 2 tenants need to leave, in which case you need to evict them, or you work with the fact that you already have 2 tenants lined up for next year. Great. Why don't we just work with that and see if we can find some 2 other people to move in? Or it sounds like from this question, those 2 people might be willing to pay the entire rent themselves, in which case, great. I would probably be giving them a new tenancy in their own names. But other than that, that seems perfectly okay. Like I say, you've got to be pragmatic about these things. Once tenants have given notice, what would happen if they rescinded the notice? I put in italics for my own benefit this thing called the Distress for Rent Act. This is a very old piece of legislation. I think it's the Distress for Rent Act 1737. And reading it's quite fun because you see the difference in the way in which legislation is written today and how they wrote it 300 years ago. But the Distress for Rent Act, as some miracle of law, although it's nearly 300 years old, still applies. And what that bit of legislation says is that if a tenant gives a notice to quit, and the landlord relies on that notice to quit, by which I mean they enter into a contract with somebody else to say that, okay, when this tenant leaves, you'll be moving in. And then the original tenant fails to vacate, the Distress for Rent Act says you can charge the original tenant double rent until they vacate the property. That's still law, and believe it or not, the Rent Rent Act does not rescind that law. I can't believe it's still going, but the fact is it's still there. So in this case, tenants have given notice, tick. What would happen if they rescinded on that notice? Well, I suppose this is where we get 2 different branches. If you have got a new tenancy signed, a new tenant lined up to move in, and the original tenant says I'm not going to leave, then the Distress for Rent Act applies. You could say to the original tenant who stayed there, right, you may want to evict them, but the eviction process takes time. But you can say under the Distress for Rent Act, I'm charging you double rent until you vacate the property. And the rent arrears would then build up, and then you may be in a position to serve Section 8 notice, which could get you possession sooner. There are different ways forward here, but that assumes that you've lined a new tenant up. The other scenario is you haven't actually lined the tenant up. So legally there's no way to rescind a notice to quit, but at the same time there's also no consequence. If everyone just says, okay, we'll just proceed as normal, then there's no consequence to that. But in theory, a tenant's notice can't be rescinded. And so in theory, a landlord could still issue proceedings on the tenant's notice to quit. But like I say, you're probably going to be in the realm of creating new law there. Be very, very careful with that approach. It might be simply easier to say, okay, no harm, no foul. We haven't set up a new tenancy yet. You just carry on staying there paying the rent. That's fine. Would best practice be to get the tenants to do a deed of surrender as soon as they give notice? No. A deed of surrender is fine as a means of kind of formalizing a tenancy end, but in of itself, it doesn't actually do anything. If a tenant signs a deed of surrender saying, I'm going to leave on a certain date, and then they don't leave, the deed of surrender isn't a magic wand. It doesn't do anything. So I would say you can get them to sign a deed of surrender, and if they leave, that deed of surrender will be a very pretty and formal way of saying, this is what we've agreed. But bearing in mind here is that a tenant isn't actually surrendering a tenancy anyway. They are giving notice. It's unilateral. So a surrender could be done earlier than the notice period. There might be some reason to do that. If a landlord says, okay, good, I want you to leave, I'll sign a deed of surrender so you don't have to see out your whole notice period. That could work, and that might be a function for it. But as I say, push comes to shove, deed of surrender is not worth the paper it's written on if a tenant doesn't comply with it. You would still have to go to court to evict them. Rent and rent in advance. Will you still be able to accept advance payments? We usually have three installments to consider student loans. Now, this is probably the key question here because this is. I might just wrap a bunch of these questions up into one point here. So this is not a question about rent in advance. This is the question about rent within the tenancy. So once the tenancy started, there are three key stages here as to what you can, I guess, one, what you can demand, and two, what you can accept. In terms of what you can demand, before the tenancy is signed, you can't take any rent. After the tenancy is signed, within a small window of time, but before the tenancy starts, you can take 1 month maximum. After the tenancy started, you can demand, you can only demand 1 month maximum, but you could accept more payments than that. So in this scenario, what I'm imagining happening here is, and the thing is that the student landlords have adapted to when the students get their payments. So students get their payments at the start of each term, so you get 3 big chunks of cash coming in. Those rental periods might be of uneven length. That won't fly post renters' rights. It's got to be month. What you could still do is accepting the fact that the students are going to pay when they're able to pay. It may well mean that your cash flow would still be the same. You'd have 3 big spikes as the term comes in, but your rent arrears, you might actually have rent arrears, but then it goes back up to 0 again. Then rent arrears going down, then back up to 0 again, just because the rent is calculated in a different way. Now, these are just numbers on the spreadsheet. In terms of cash flow, it will be exactly the same cash flow as you've had in previous years. It's just that you can't charge it termly. The tenants can pay it termly if they want to, but you can't force them to do that. So if they want to stagger their payments by month, that's the law. That's perfectly okay. If they want to say, here's 3 months rent as one big chunk, you can do that as long as the tenancy has started. You can't do that before the tenancy started. Otherwise, that's an unauthorized payment. Where rent has been paid in advance, can advance amounts continue to be taken post 1st of May? This is kind of a similar question, really, but for an existing tenancy. If you have an arrangement where the tenant is paying big chunks of cash to coincide when they get the student loans, the tenant can pay those funds as long as the tenancy has started, but you have no mechanism to force them to pay as long as they're paying monthly or whatever the term you've agreed is. We have a lot of international students that don't have UK guarantors and usually have paid rent in advance. So we always ask if they can pay rent in advance. The guarantor company is very expensive. Require payment except payment. Now, this is basically to do with our guarantor providers. So you have professional guarantor products. I name a few names: Housing Hand, Rent Guarantor. I say a bunch of other people are trying to get into this market too. So I think Good Lord are doing one. I think Lettings Hub are doing one. Lots of providers out there. So I'm not endorsing anybody in particular. They are Tenant Fees Act compliant. Now, I don't have the time to explain why. Take me at my word. As far as I'm concerned, legally, all those things are Tenant Fees Act compliant. So, but rent in advance is not Tenant Fees Act compliant. So you can't accept rent. You can't accept rent in advance. You could either not take rent in advance and just take the leap of faith, but you're entering into a contract with somebody where you don't have the assurances that they're going to pay, or you simply ask that they speak to a professional guarantor provider, in which case they can pay for that product, and the landlord may be accepting of that. But you don't have to. You could just take them if you wanted to do that, but it might be a bit too risky for some landlords to want to do. Okay, we've got other questions, and I've got about 10 minutes. I'm appreciating there are some questions here, so I'll just speak as I can. Are there any changes to EPC rules around HMOs? No. Currently, if you're renting out room by room, you don't need the EPC for each room. There's no rule changes there. My business is sole students. Will I be able to refuse pets? No, that's not a good enough reason to refuse pets. You need a very compelling reason. And for the record, the landlord being allergic to pets is not a good reason. The only good reason in the legislation, the only good reason is basically if some other third party disagrees with you. So if you're renting a flat in a block of flats and the freeholder says no pets, then you could justifiably say that. But I think that also works even if you are the freeholder. I think you could justifiably say in a block of flats it's not appropriate to have a large pet, like a dog or a cat, but you still probably wouldn't be able to refuse a small pet, like say a hamster or a goldfish or something like that. So just being a student landlord doesn't automatically mean you can refuse pets. As tenancies will be periodic, will guarantors be able to give notice? The broad answer to this is no, because most guarantor agreements, most properly written guarantor agreements, will not allow guarantors to give notice. So check your guarantor agreements, check what it says. Most guarantor agreements just bind them for as long as the tenancy exists. Can we charge international students for a company guarantor product where they cannot provide enough income? Yes, you can. Our current process is that we allow tenant swaps up to until a minimum more than half the group. I think this is quite a long question. At which point we asked that there was a short gap so you could do a clean inventory. Where is the line drawn between too many changes? So this is really a question about tenant churn. So basically, how far along, how many tenant swaps can you do before you really need to just say this is a new tenancy and just have a break? The fact is that you can't force a break. That could only be done with the tenant's consent. It sounds like these people are already doing that. So maybe you've got some very compliant tenants. The push comes to shove, you can't force them out just to create a break. And the answer to the question is, where is the line drawn? There isn't really one. If you do a tenant swap, that's a completely distinct tenancy, and that can continue forever. The fact you don't have an inventory or a relevant inventory is relevant, but it might also indicate the fact that there's probably going to be some wear and tear because there's obviously been a big period of time where the property's always been occupied. So you might not be able to claim kind of those damages anyway. So yeah, there isn't really a hard line for this sort of thing. Oh, I made it. Okay, great. We've got a few minutes to do some Q&A. So Nick, talk as quickly as you can to get the juiciest questions and we'll see what we can do.
So, Ryan,
I'm going to drink some water.
Yeah, no, thank you so much. Actually, Ryan, we've had quite a lot of questions in. So because we've got a hard stop at 5 to, what I'm going to suggest is that we do a follow-up session so that we plan it in so that we can address some of those questions and then everybody gets an answer if that's okay. So I'll pick that up with you offline. So just wanted to, there was a couple that I just wanted to explore.
Yeah, of course.
So, and this is a really chunky one. And I think for me, joint contracts and serving notice is one of the trickiest things that our student landlords are going to have to deal with.
Mm-hmm.
Now, I understand what you're saying. So your position is, at the moment, if one tenant gives notice, that ends the whole tenancy. Now, I had seen discussion whereby I think it was David Smith or somebody who had suggested that there was some case law that suggested, where a judge suggested that if a landlord puts into the contract that all tenants have to give notice, then that means that all tenants have to give notice.
Fine.
Is that correct?
I remember. I do. Remember, I watched what you watched. Most sensible people on this webinar will be watching whatever David Swift says anyway. That question was about requiring all tenants to give
Yes.
notice, as opposed to one person's notice being on behalf of all of them.
Yes.
And I don't want to repeat what he said, but it is, as far as I'm concerned, correct. Very risky ground, because that isn't something where there's been any decisions as far as I'm aware.
Right.
And you are restricting a tenant's ability to give notice, which is a big no-no in Renters' Rights Act. So
Okay.
that is more than the law currently supports, but the only way
Okay.
the law is going to get expanded is if you get some very brave, dare I say, reckless landlords who want to try and push the boundaries a little bit. There will be some landlords who want to try that, and we'll see what the courts say.
Yeah, no, that's really helpful, Ryan, because I think if there was some way of doing that, that would effectively, I think, for a lot of landlords, look like the status quo, because a lot of our HMO landlords in particular offer joint contracts. And if all tenants have to serve notice together, I think that that would alleviate a big issue, which is the one tenant giving notice who needs to leave early and then dealing with the three remaining tenants. So
Yeah.
I think what you've said there is at the moment, stay away from that and wait and see what happens. So that's really helpful. I think, let me have a look, see if there is anything else that chunky that we would like to deal with. Yeah, so do we assume, Ryan, that if all tenants start off as students and somebody graduates sort of before the end of the tenancy, that's effectively fine. I mean, I assume the landlord can't be responsible for if it's at
Yeah.
the beginning when you enter into a tenancy.
No, that's fine. That is a good question. The so this is again one of those restrictions on ground 4A is that the is to do with the tenant having a student status. Now that student status, the wording is, I believe, the landlord that they either are a student or the landlord either reasonably believes that they are going to be a
Yeah.
student at
Okay.
the start of the tenancy. So if they graduate, fine, because it happened during the tenancy.
Okay. Perfect. And last one, because I'm going to let you go. I know you've got another call. So, in the event that in the joint contract, the scenario you touched upon, okay, three people are remaining. Yes, pragmatically, you can work to fill the room. If, for sake of argument, the total rent is £1,000, would it be appropriate for the landlord to say to the students that are remaining, the three students remaining, well, you split that total rent between the three of you? Is that appropriate or not? So does the
If
landlord have to swallow the rent loss from the person leaving?
Um, that is one of those pragmatic discussions, really, isn't it? Because if they can't fill that room, then I think the landlord would be justified and say, well, the entire property is X amount of money, and you guys are renting the entire property. So yes, you ought to pay more rent than you're currently paying because there's simply fewer people to split it among. That's a practical consideration. They might simply say no. And again, the landlord is then left with that situation where, well, what are they going to do about that? Do they evict these people? Do they not? Um, it's just one of those things they're going to have to deal with on a case by case basis, I'm afraid, rather than it being like some one right answer that will fix every solution.
Yeah, I think final word for me. I mean, given your answers on joint contracts, it just seems to make much more sense for student landlords to operate on individual contracts
Yeah,
rather than
it,
joint contracts. Joint contracts just seem extremely tricky to operate under the new regime, and
yeah.
it just seems to me like you're going to
Joint
end up.
tenancies. If there is like a right or wrong answer to whether to not to do room lets or joint tenancies do have a lot of extra problems that come with them. Whereas
Yes,
if you have a room let, tenant gives notice, you just have a room to fill. That's not
yes,
it's not so hard. Um,
similar, yeah, similar to what happens now, effectively.
yeah. Just to go back, sorry, 'cause I kind of weaseled out of an answer to the previous one, which is to say, as far as I'm concerned, by the way, if the rent with say four tenants is £4,000 just to make the maths easier, and
Yes,
one tenant gives notice, but the three tenants stay on. If nothing really changes, I think the rent is still £4,000 a month, but
okay,
three people are paying it instead of so I don't think it automatically shifts down to three. This is what I'm saying is that I think everyone's got an incentive to do something about it because the tenants presumably don't want to be on the hook for the higher rent, but they might be accepting of the fact
yes.
that they might have to be unless they want to leave.
Okay, wonderful. On that note, if we can leave it there, I just want to say thank you. I know you're really busy at the moment and you're jumping onto another call, but I will pick up offline with you about arranging something maybe next month and we can cover the rest of these questions that have come in. It's obviously fertile ground, but thanks, Ryan. That's been absolutely
Yeah, no problem
fantastic.
at all. Thanks for having me. I hope it was helpful, and we'll have a follow up to the follow up, and there may even be a follow up to the follow up to the follow up with the way
Like
things are going.
the Godfather trilogy, yeah? And
Yeah.
perfect. Thanks a lot, Ryan.
Thanks very much. Have a good one. Bye.